What does the NCDC Bill, or Infectious Diseases Bill, as it is otherwise known, intend to achieve if and when it becomes law? Why is opposition to it growing by the day? What informs the apprehension that many Nigerians have expressed about it? Many questions demanding immediate answers, for which we now turn to Honorable Kingsley Chinda, a member of the House of Representatives representing Obio-Akpo Federal Constituency in Rivers State. Honorable Chinda, good morning. Welcome to the morning show.
Good morning.
Good morning. Good morning. Thank you for joining us. Well, the Infectious Diseases Bill has been very controversial. You have, on one hand, the Speaker of the House of Representatives, Honorable Femi Gbajabiamila, who is a co-sponsor of the bill, saying that the bill is in the public interest. And then you have some members of the House of Reps and also the public saying that the bill is dictatorial, it erodes in many parts fundamental human rights, and that it's a product of inducement by certain interests, and that above all, it is an attempt to turn Nigerians into guinea pigs. Now, you are a member of that House, and you've been part of the conversation, and you've had the opportunity to take a look at the bill and probably also contribute to the debate. Is that bill really in the public interest, considering the objections that have been expressed by civil society, by members of the House, by Christian Association of Nigeria, and by a cross-section of concerned stakeholders?
Well, thank you for the opportunity. Let me straight answer the first question, whether the bill at this point in time is in the interest of the public. My answer is yes. Nigeria needs a new bill that will take care of emergency situations, particularly as it pertains to infectious diseases, because of our experiences, both during the Ebola era and the present COVID-19. And so I will start by commending the sponsors who were foresighted and the spirit behind the bill. But then, whether the nature of the bill we have now is opposite in the circumstance, my answer again is no. It is not, because of the content of the bill. I commend the spirit behind the bill, I commend the foresight, but I think that we really need to rejig the content of that bill. If I have the space, perhaps I will just take us through the bill slightly. From the commencement, of course, we have heard the criticism that the bill was copied from the Singaporean version, and there's nothing wrong with that. As far as issues of plagiarism is concerned, statutes and legislations do not fall within that purview. But in adopting foreign statutes, you must consider the local circumstance. And so when you bring them in, you must adopt them in line with the local circumstance. This particular bill did not consider that at all. This is a bill that came up in Singapore under Lim Kuan Yew, a single-party government then. Of course, most people criticize Lim Kuan Yew that he was very dictatorial, though he made fundamental improvements in Singapore. But Nigeria is operating a multi-party system democracy, and it's a federation. And so there is serious need to adjust that bill to our own local circumstance. I'm one of those who feel that the bill is very draconian in nature, but I don't believe that we should throw it away. Rather, we should rejig it to adjust it to suit our local need.
Honorable
If we go into...
Do continue, Honorable Chinda. I was going to ask you if we could go into more details with regards to what you would like to see rejigged in the infectious diseases bill that has been proposed.
Yes, let me even start with the long title of the bill, which is the Control of Infectious Diseases Bill, and to make provision relating to quarantine and make regulations for preventing and spread in Nigeria of dangerous infectious diseases. Now, if you look at that title, the impression is that the bill has to do with only infectious diseases, because we're talking about control of infectious diseases. But Section 5.1 of that bill also gives powers to the minister to move into any other disease, which means it goes beyond infectious diseases. That is the title first. Now, if you also look at the office of the DG of NCDC, which was not created by this bill, all the powers to administer this bill were given to the office of the Director General of NCDC. And you know that the Director General's office was created by another law, which is the Nigerian Center for Disease Control Act 2018. That's the NCDC Act 2018. And powers were also given to that office, including a board that was established under that bill. And under the present Infectious Diseases Control Bill, which we are discussing, some of the powers of the board in NCDC Act of 2018 were given directly to the DG alone, which runs contrary to that other bill. And if you look at sections of the Constitution, you find out that particularly Chapter 4 of the Constitution is grossly abused by the contents of this bill. I will also come to the argument that, yes, Section 45 of the Constitution allows for that, which I do not agree with. Now, if I have the time to take some of the paragraphs of the bill to show or expose the issues complained of. Firstly, the president is given the power to declare a public emergency in the president bill that is being considered, particularly I think under Section 3 of that bill. Now, the bill went further to say that the president will publish such declaration, but did not determine how the publication, what form it should take. What it means is that the president can just make a declaration and then decide to place the declaration in his office, a notice board in his office. He has fulfilled the content of that law, whilst we know that this should be done in form of a gazette. So what stops the bill from telling us exactly how this should be done? Now, Section 6 also provides for compulsory testing. On mere suspicion, the DG has the right to order for compulsory testing of persons residing within an area if he suspects. My own concern is, yes, if you fail to undergo that testing, you commit an offense. But again, how do you publish that? It is also not spelled out in the bill. Section 7 empowers the DG to order post-mortem tests based on suspicion. And you know the implication of that. It also empowers the DG to stop even a wake keep based on suspicion. So my worry is, most often, things like wake keep, burials, and all that has religious coloration. If you are conducting a wake keep and the corpse, the suspected corpse, is not even there, why do you need to stop that? That clearly infringes the constitutional right to freedom of thought, religion, worship, freedom of association. And then Section 12 empowers the DG on mere suspicion again. That's the area that talks about the wake keep, on mere suspicion, to stop a wake keep or burial of any person. Section 14 empowers the DG to place a citizen under surveillance on mere suspicion. I keep emphasizing the word mere suspicion, because what that means is that it is discretionary. Section 15 empowers the DG to issue a notice and take over a citizen's property and declare it an isolation center without the consent of the owner. And in Nigeria today, we know what obtains. What it means is that the DG enjoys so much power, even against the provisions of the Land Use Act, which vest all powers in the state on the governor. So without the consent of the governor, the federal government, through the DG, can acquire any property in any state under this law. Going further to 16, Section 16 of that same bill, if in the opinion of the DG, any building is deemed to be overcrowded, he could make an order dispersing the crowd. And so if people are worshiping in a building, you have a church or you have a mosque, and the DG feels that it's overcrowded and is likely to expose the occupants to infectious disease, he could order that that worship should stop. Or even a meeting, that such a meeting should not take place. And take note, these are based on mere suspicion, no confirmation. Section 19 goes further. to strengthen that power. And then if you look at Section 24, it empowers any enforcement officer. I didn't even say that the DG, I think Section 2 of that bill, has the power to appoint anybody as a health officer to enforce this bill. And that also runs contrary to the health officers, to the Environmental Health Officers Council bill law, which is in place, which states that for you to be a health officer, there are conditions that must be fulfilled. The present bill we are considering empowers the DG to appoint anybody as a health officer. Now, you will also recall that Section 24 of this same bill empowers any enforcement officer to get an order from a court, and that court is a magistrate court, to destroy any building where an infectious disease would have occurred. My worry and concern is, do you need to destroy a building to curb an infectious disease? So if anybody who has an infectious disease has dwelled in a building, you have given the DG power to ask that that building should be brought down because of that person, whether the person is there or not. That is not a solution. Of course, you can sanitize. You can sanitize the building, you can disinfect. There are other ways. This is too draconian. That's my position. Also going further, Section 27 allows the DG to exempt a vessel that is coming from an area that is infected. Generally, any vessel coming from an infected area is deemed to be infected. But Section 27 now gives the DG the discretion to say that, look, vessel A is not infected, even if it is coming from an infected area. And there are no conditions under which that kind of exception should be given. It is still discretionary. Section 30 gives the DG the discretion to determine any vaccine that will be compulsory to citizens for them to be taken in a particular area. And it also goes further to say that if you fail to take that vaccine, you cannot travel outside this country. That is unknown to us. What we have known is that countries give conditions for entry. If you know that you need vaccine against yellow fever, you give that as a condition for entry. And anybody who is coming must be ready to fulfill those conditions, but not for citizens to leave the country that you must have a particular vaccine with. I think that that is not proper. Now, Section 47 also talks.
Well, yes, I think the point is well made about the draconian nature of the law and the excessive powers given to the Director General of the NCDC, who is mentioned 134 times in that piece of proposed legislation. Even in Sections 55 and 57, there is conflict of powers in terms of the definition of who is a health officer and the responsibilities of the police. But I would like to ask you, now, this bill was brought up on April 28 in the House of Reps. That same day, it went through first reading, second reading, and there was an attempt to take it through third reading. Is that standard procedure in Parliament? And the Director General of the NCDC, who is a major stakeholder, has said on more than one occasion that the NCDC itself was not consulted. And if you look at the bill, all through, there is reference to the act. It's referred to as the act, as if it's already a fait accompli. These are the grounds for some of the suspicions that have been expressed, that the bill is not inclusive and consultative enough. What's your reaction to this? Also about timing. The DG of the NCDC says the timing is not right, that you don't propose this kind of legislation in the middle of a pandemic.
I agree completely with the DG that the timing is not ripe. Let me not use the word right. I would say that it is not ripe. Because we are in the middle of a pandemic, there are things that we will still learn as we go on. By the time we conclude with this whole pandemic, I'm sure that there are new revelations. I give an example. The Speaker even asked the DG whether in the old law there is provision for those who escaped from the quarantine center. That is an experience that was revealed as a result of this pandemic. I believe that there are more things that will be revealed to us who needs to be captured in that bill. So we need to slow down a little bit. Like I have said, I commend the Speaker for initiating this bill, but then we need to open it up for people to make contributions so that at the end of the day, we'll come up with a very quality bill. Remember that the Quarantine Act that we seek to repeal has been in place from 1926 or so till date. And that Quarantine Act even covers grounds 29 up till date. You can imagine how long that bill stood the test of time. It is under that Quarantine Act that governors today are making executive orders to help them to fight this pandemic. And under the new bill that we seek to bring in place, governors were completely excluded. The fact that this is a federation was ignored, regardless of the fundamental fact that health is under the concurrent list, where state governments also have a role to play. So I think that we should slow down a little bit. I'm happy that the Speaker showed leadership when he allowed this bill to go back for public hearing. I commend him for that, and I pray that that public hearing should be open, should be transparent, should be accommodating to all Nigerians, so that we can be proud tomorrow when we are not in the House to say, yes, I was part of those who came up with this very wonderful bill. Unlike a bill where we rush into coming up with a bill and then tomorrow people will begin to ask, who are the legislators that came up with this kind of bill? So I agree that we should slow down a little bit, allow this bill to go to the public, let associations, organizations, individuals make their input, and also understand that this bill touches on private rights. And our House rules provides that where we are coming up with a bill that has to do with infraction of a private right, that individuals should be allowed, those who are affected and indicate interest to be part of it, should be allowed to appear before the committee, either in person or by their legal solicitors, by their counsel. So we must fulfill all that to ensure that we'll come up with a bill that is acceptable to everybody.
Certainly, Honorable Chinda. Now, how do you also respond to critics of the bill who say that there is so much room for this bill to be heavily politicized if enacted into law? Past sections that you mentioned, like Section 15, which gives the Director General the authority to actually take over any premise and make it an isolation center, or Section 20, if I'm permitted to read, states where it appears to the Director General that the holding of any meeting, gathering, or public entertainment is likely to increase the spread of any infectious disease, the DG may, by order, prohibit or restrict, subject to such conditions as he may think fit, for a period not exceeding 14 days, the meeting, gathering, or public entertainment in any place. The wording of the bill and the tone of the bill is quite suggestive that it can be heavily politicized. What is your take?
Again, I completely agree that by the wording of that bill, not that it's likely, it will be politicized, considering the history of this country, the political history of Nigeria. Anybody who becomes director of the MD of NCDC and is given these powers, of course, their appointer belongs to a political party. We practice a multi-party system, unlike Singapore, where they had just one-party system. They all belong to the same political party. Here we belong to different political parties. It will be politicized. And I think that that is the areas that we should look at. Even where you want to give such powers, it should be tied to conditions so that when you exercise it, it's not completely discretionary. Conditions must be fulfilled for you to exercise such a power. But I don't think that it is proper to leave it the way it is now. Besides the fact that it will encroach on other existing laws, particularly the Constitution, the Land Use Act, it will also lead to serious abuse. I'm one of persons that do not believe in excessive discretion, not even to myself. Don't give me that kind of discretion.
Very right, Honorable Chinda. Too many discretionary powers and too much ambiguity and lack of clarity in that proposed piece of legislation. Very quickly, at the same time, the Senate is also considering what it calls the National Health Emergency Bill. And the House of Representatives is talking about the Quarantine Act, Repeal and Amendment Act. What is the difference between what the Senate is contemplating and what is being debated at the House of Representatives? If you may assist us in that regard.
Yeah, I've not seen the Senate version of the bill, but from the interview that the sponsor of that bill in the Senate had, I think they appear to look alike, but that's not also a problem. I believe that legislators should come up with bills at the appropriate time. We'll have time for a conference where both chambers will meet and harmonize areas that need to be harmonized. The most important thing is that we should make laws that will help in instilling peace and progress in our country in line with Section 4 of the Constitution, which empowers us to make such laws. So I don't see any problem with that. At the appropriate time, we will harmonize both bills and come up with an instrument that will be acceptable to both chambers.
Honorable Chinda, thank you.